captions, which can be found on the toolbar at the bottom of your screen under the More button. You should enable closed captions by choosing English as the speaking language, and then your language of choice for the translation. Again, you can find this at the bottom of your screen under the More button. Enable closed captions by choosing English as the speaking language, and then your language of choice for the translation. If you need assistance, you can direct message Camille Gallardo. Okay. Next slide. Please know that we record our events to share with everyone unable to attend. Recordings are posted on NYTA's YouTube channel. You can subscribe to our channel and view this and past recordings by going to youtube.com/New York Tech Alliance. And for anyone joining us for the first time, the New York Tech Alliance is a nonprofit dedicated to serving and strengthening the New York Tech community here. At the core of our mission is a commitment to diversity, equity, and inclusion. And our core activity is to lower barriers and increase access to the information, knowledge, and resources and connections people need here to grow and succeed. You can learn more about us, including our monthly meetups and other programming at www.nitech.org. I'd like to thank our annual sponsors, especially Ellis Law Group, sponsor of today's event, who help make events like this one possible. Each has a presence on our website. You can learn more about them and how they support our community by going to nitech.org/sponsors. I'd also like to recognize Civic Hall. The Tech Alliance is a part of Civic Hall, which is a nonprofit focused on tech for civic good. Civic Hall opened its new location near Union Square here in New York City a little over a year ago, and it occupies floors 2 through 7 of this beautiful new 22-story glass building. It's about 85,000 square feet. And in addition to meetings and events, Civic Hall is home and host to many education partners who provide digital training skills to a wide variety of people. It also offers individual and organizational memberships to the tech community. Civic Hall is providing a free trial membership to everyone attending today. If you'd like to take advantage of the offer, scan the QR code on the screen and submit your information. We'd love to welcome you and have you part of our community here. Okay, with that, I'd like to welcome and introduce Paul Ellis, Managing Director of Ellis Law Group, who will be leading today's discussion. Hey, Paul.
Hey, Doug. Thank you very much, and welcome to all. Nice to have this group together today. I had some great conversations in the breakout room, and I hope I'll have a chance to meet more of you afterwards. So again, welcome to all. My name is Paul Ellis. I am a co-founder of Tech Alliance, a board member, and I run this series of events on legal issues for small and mid-sized companies. This one today, a great topic, entering the US market, critical legal considerations. This is something we've done before. It's been very well received. I recognize we're talking to people from around the world. I've looked at the participants. I see a bunch of people in Europe, the Eastern Europe. So I know we got a bunch of different time zones going. We'll try to keep it engaging and keep everybody awake, regardless of what time it is, wherever you are. So we are going to start with quick introductions of the panelists, and then we will get right into content. So I am managing partner of Ellis Law Group. We are a boutique law firm with offices in New York and lawyers in Chicago, San Francisco, and LA. We have a client base across the country and around the world. We work with small and mid-sized companies in the life cycle of issues facing those companies, such as formation, financing, IP protection, employment, equity plans, general operations, and exits. We do a lot of work for companies outside the US, especially the UK, EU, East Asia, on those and other issues. For our foreign clients, we're generally dealing with things like assisting them with structuring, figuring out how they need to structure their company to come to the US, forming subsidiaries. We do IP employment. We do M&A work, exit work as well for M&A transactions that touch the US. Our lawyers all come out of top law firms and the top law schools, so we're able to offer the high-level expertise of the big firms at a more reasonable cost structure and with more personalized attention. If anyone would like to meet with me, send me an email, or my Calendly link is on the screen now. Feel free to set up a time at some point later this week or next week. With that, I will turn it over to Alex.
Good afternoon, everybody. Well, good afternoon here in New York. I'm Alex Rubin of counsel to Ellis Law Group. I'm the go-to employment lawyer for all of our clients. Anything employment related comes across my desk, and I'm able to help all kinds of companies, entrepreneurs with their employment law needs here in the U.S. and in particular here in New York.
Alex, thank you very much. Ted.
Hi, I'm Ted Sabity, and I'm an intellectual property and technology attorney that works in a variety of fields and with the Ellis Group for many years. Paul, I think we've worked together now for almost 20 years. We do a lot of
I try not to count, Ted.
Oh, so anyway, we do a lot of work for clients in Europe. We also have a lot of clients across the United States. We do patent work. We do IP litigation, technology transactions. I'm doing a lot of licensing work now for some companies out of Silicon Valley. So we get involved with a lot of cross-border issues. And we do a lot of computer-related stuff. We're doing some fashion work in branding. And with trademarks, we also get involved in copyrights and music licensing and other kind of entertainment-related things involving that. So sort of a wide thing in that field, and so that's what we do.
Ted, thank you very much. Michael. Michael's still muted.
There we go. Apologize. Anyways, my name is Michael Cerati. I'm the senior partner of Cerati Law Firm. We focus on immigration. There's about 27 people in my firm. I would say a majority of our clients are Silicon Valley, New York City startups. We also represent a number of large multinational billion-dollar corporations and a lot of investors and entrepreneurs. I personally enjoy dealing with entrepreneurs who are entering the United States market, providing them with, I like to think of creative solutions to come here and do what they need to do to build their company. Paul and I have been working together for a number of years, and I enjoy these seminars, and even at my advanced age, I still enjoy helping people across the world and listening to their stories and helping them come here. And just a quick note, listen, Mr. Trump is now the president of the United States. I will tell you that when he was president before, business immigration was great, you know? And so whatever information you're reading out there in the internet about concerns, I personally don't have any concerns. I've seen it before. He's supported by a lot of tech executives, and they truly do enjoy the opportunities for foreign nationals to come here legally and build their companies. So thanks, Paul.
Mike, great. Thank you. And Jack.
Hello, everyone. Jack Wilk. I'm a tax lawyer based in New York City. I too have been working with Paul for longer than I dare say, but probably north of 20 years. I focus on taxation. I do a lot of work for companies of all size on structuring both inbound and outbound transactions, where companies, either U.S. companies doing business outside the U.S. or, for purposes of this seminar, non-U.S. companies entering the market. We also do state and local taxation, warning every people, being cautious of the various different rules of different states. And as I was mentioning before, it's become increasingly difficult with state taxation now that every company has so many remote employees. And I've been given 10 minutes to discuss a topic that we could probably discuss weeks for, but I will do my best when it's my turn. Nice to meet everyone. Thank you.
Jack, thank you very much. All right, so we can jump in. I'll just say in short, first, again, really pleased to have this panel together. As noted, this is really the team that I look to for my clients coming from abroad. Each one, really does outstanding work in their field, and as a group, we're able to do really solid work for our foreign clients that are entering the U.S. So I'm really pleased that they were all able to participate today. What are we going to cover? Well, a lot in not that much time. We did this a couple of years ago. We did it as a 1-hour event, and it was just like drinking from a fire hose. So we expanded it a little bit so everyone has a little bit more time to talk, but it's still a lot of material. We are going to start with corporate law. I will be talking about that, talking a little bit about the structures for companies entering the U.S., considerations. Then we'll go to Jack on tax. Tax and corporate really go hand in hand, so there's a good bit of overlap in these two areas. After that, we'll go to intellectual property with Ted talking about patents, trademarks, copyrights, trade secrets, and the like. Employment with Alex, and then immigration with Michael. And then we will wrap up with a few observations on the other sorts of service providers that you may be needing, bringing your company to the US beyond the lawyers. So a few general observations. This is really high level today. In 10 minutes, all that we can do is really identify issues for you, identify the questions. We can't necessarily give you answers, but the idea is to sensitize you to the things you need to think about when you're bringing a company to the U.S. What are the decisions? What are the issues? So you're aware, as things move forward, when you need to go out and seek more advice. Not all of these topics are relevant to all companies. Generally speaking, corporate and tax come up with, most companies entering the U.S. After that, it really depends. If you're entering the market and your branding, your IP assets are important, obviously you need IP advice. Employment, it depends. Some of my clients are bringing employees or will have employees in the US, some of them not. Immigration, same thing. Even if they have employees, they may be engaging employees located in the US, but there'll be some companies that are bringing people from abroad. In that case, you need immigration. So what of these different areas are important to you really depends on what you're doing in the US, what your objectives are. I have companies that are coming that are simply, they're accessing the US market. That's what they care about. Others are looking for talent. They want to bring on employees. Others may be looking for partnerships, or maybe they're doing acquisition work. So there are all sorts of reasons that companies are entering the US. And as I note in the second bullet, those objectives are always going to drive the structure. Whether, and we'll talk about that in a minute, do you need an entity here, or can you get by as a branch? If it's an entity, what is the structure? Is it going to be a subsidiary structure? Is it going to be a Delaware flip? Again, it's going to depend on what the objectives are for your business, why you're coming, what is the value you seek by being in the US, and that will drive the business structure as well as the types of legal issues you need to address. As I noted, can't answer all the questions, but we at least want to make you aware of the issues. And lastly, I think by the end of this, it'll be clear that when the moment comes, it is important to consult with a lawyer and to make sure that you are getting the right advice. Generally speaking, it is not difficult to enter the US market, to set up a subsidiary. It can be done relatively cheaply, both in terms of filing fees and legal fees. And there are a lot of benefits to it, but it is important to get it right in the beginning because things just get more complicated along the way. So with that, let's go to the corporate issues that I will touch on briefly. It's worth noting at the outset when you're entering the US to appreciate how the federal system works. It's worth thinking of the US as really, you have 50 states with 50 different legal systems. Now, that doesn't mean that you need to know the laws of each of these 50 states in order to enter the market. But it is worth understanding that there is a different system of law within each of the 50 states. How important that is for you and your activities, the activities of your companies, depends. Some areas of the law are very state specific. A good example is employment, and Alex will be talking about that, about how the employment law of New York is very different from the employment law of California. And so you really need to, when you're hiring employees, you need to think about where they are and what are the laws that apply. On the other hand, there are areas of the law like patent or immigration, which are largely more national bodies of law, federal law, and state considerations don't play the same role. So again, it's worth understanding how the federal system works and that there is state-specific law. Whether the extent to which it matters for your company, for your activities really depends. Again, something to discuss with your lawyer. So when you're coming to the US, an initial threshold question you need to consider is, are you setting up an entity or are you just going to function? Are you just going to begin operations in the country without setting up a separate entity? This decision is largely tax driven. Jack is going to go into the tax consequences of that, but it's worth recognizing the threshold question and recognizing the other issues as well. There are liability concerns as well. If you form an entity in the US, that will help to shield the parent entity in a foreign jurisdiction from the liabilities of the US operations, which certainly can be a compelling reason given the US, which tends to be litigious. There are other considerations as well. There are large companies in the US you may wish to partner with that may want to partner with a US-based company. And it's not just what's required, it's also optics. There will be larger corporations in the US that will feel more comfortable contracting with an entity set up in the US. So there are a number of factors that play into this consideration as to whether you are actually going to be setting up an entity or simply commencing operations of the foreign entity in the US. And again, the tax considerations are significant. Jack will talk about them. As I noted, if you are setting up an entity, it's relatively straightforward, relatively inexpensive. So let's assume that you are setting up an entity in the US. And the next question that you need to address is, what is the relationship of this entity, we'll call it NewCo, to the overseas company? Again, objectives drive the structure. I will say that if your company is coming to enter the US market for the sake of seeking customers in the US, partnerships in the US, talent in the US, likely the NewCo will be a subsidiary of the foreign parent. It will be 100% owned by the foreign parent. In the alternative, we often have companies that are coming to the US to access the venture capital market. They want to attract investment from US investors. And those investors will at least sometimes prefer to invest in a US company, usually a Delaware company, rather than the foreign company. In that case, we will do what we call a Delaware flip, where there will be a stock for stock swap, such that at the end, the equity holders of the foreign company will trade their stock in the foreign company for equity in the Delaware company. The Delaware company will become the topco, the parent company, and the foreign operating company will become a wholly owned subsidiary of the Delaware company. Now, in terms of business operations, nothing much changes because the foreign company
Okay, I'm doing a Zoom that's going over legal stuff going on in New York right now. Just feel free to chat me.
because that doesn't change the business operations, because the foreign company, the foreign sub will continue to operate the business, but it does create financing opportunities because the parent company in the U.S. Can attract VC investors in the U.S. So that's something that we will often do in the financing scenario. Another consideration is the type of entity. The most likely choices are a C corporation or a limited liability company or an LLC. To a large extent, this is tax driven. I will leave that to Jack to talk through the relative benefits of a C corp or an LLC. I will say, generally speaking, most of our clients that enter the U.S. market and are forming a subsidiary will go with the C corp. We can have the next slide. The next question to be addressed is the jurisdiction of incorporation. Because if you are forming a corporation or an LLC in the US, it will be formed in one of the 50 states. As many people are probably aware, Delaware is generally the favored jurisdiction for most corporations formed in the US. There are a number of reasons for this. The corporate law is very well developed. The court system is very experienced in addressing corporate law issues. There's the filing service in Delaware is efficient and predictable. Also, many of the forms that as corporate lawyers we use for companies in the US are based on Delaware law. And in addition, the Delaware law really functions as a lingua franca in some ways in the US. Most corporate lawyers in the US will know the law of their home state as well as the law of Delaware. So in a way, Delaware is sort of a common legal language in the US. Having said that, there are other jurisdictions that to be considered. Wyoming has made itself very hospitable for crypto companies. And so there's certainly many companies that are in the crypto space will form in Wyoming. There are certainly other jurisdictions where companies form, some in New York, some in California. And I would say in recent weeks and months, there have been some defections, some high-profile defections from Delaware to Texas. I think the jury is out on how that plays out over time. Some people have come to me recently saying, well, are things changing? Is Delaware still the default? I would say that it is. Texas is presenting itself as an alternative at this point, but I think most corporate lawyers, from our perspective, Delaware is still where we see companies forming, and it certainly is the case that Delaware continues to do everything necessary to make itself a very hospitable jurisdiction. Last couple of points, distinguish between incorporating and qualifying to do business. Incorporating is what you do in your home jurisdiction. So you would incorporate in Delaware. That doesn't mean that you would need to be operating in Delaware. You can have your home office. If you have a home office, it could be New York, California, anywhere else you like. There is a concept in the US called qualifying to do business. So if your activities in a given state rise above a certain minimum level, such as having a home office, having significant employees or operations, you will need to qualify to do business in that jurisdiction. Again, not something you necessarily need to do in 50 states, but you might need to do it in at least a few states. That's relatively straightforward, just costs a few $100s. Beyond the forming your entity, there are ongoing compliance issues you will need to be aware of. You'll have annual franchise taxes in the state where you're incorporated. You'll have income tax returns, federal, state, and in some cases local. Jack may talk a little bit more about that. And then there are other compliance obligations. There may be employment-related issues, compliance with local laws. Depending on the type of business and the jurisdiction, there may be business licenses or registrations you need to be aware of. Those are really features of local law that may come up. So that is a quick survey through some of the corporate and related considerations. With that, I will turn it over to Jack to talk about tax.
Hello, everyone. I'm going to break my presentation up into basically two parts. One is an overview of the general U.S. taxation rules, and then going in, following up what Paul said about the basic way of structuring your U.S. business. So basically, in the United States, there are three separate taxable regimes for most companies, and I'm talking about taxable income. You have the federal, which is by and far the largest rate. Then you also have state taxation, and in some cases, you have local taxation. In today's day and age, the U.S. federal rate is low, and some people now consider the United States almost a tax haven. The rates are 10 to 15% lower than they used to be, 10 years ago. Of course, in the United States right now, there's no certainty as to what's going to happen with tax rates. As I said, every state and city is different. So, for example, if you set up business in New York City, as an example, you'll pay federal tax, you'll pay New York state tax, you'll pay New York City tax. It's not necessarily as bad as it sounds, because quite often you can deduct the state and city tax against the federal tax, but when you add up all the rates, it can end up being a high percentage. But of course, many companies think it's still worthwhile doing business in big cities, and the big cities tend to have the highest local tax rates. Another big consideration in the United States is, and it comes up all the time, is if you do business in more than one state, you're going to have to allocate the income between and among the states. The states are very aggressive about trying to allocate as much as possible to their particular states. And it's, the reason is quite simply that they're looking to raise as much money as possible. And what's happened in the last few years, post-pandemic, with the onset of remote workers, state taxation has even gotten more complicated and confusing. You're a New York company, but you have one employee working in Ohio. Do you have to pay Ohio state tax because you have someone working from Ohio? It's become increasingly complicated. So you have to be sensitive if you have remote employees, which was in today's day and age is very common. In addition to state taxes, state income taxes, there's also other taxes on business. I would say the most common tax that people worry about is sales and use tax. And what's also happened over the years is that the definition of what kind of transactions are subject to sales and use tax has broadened. All the states are increasing their definition of transactions where they want to collect sales tax. Once again, this is just, quite simply all revenue driven. Now to turn around to talk about the specific structures, which Paul already mentioned. There's two basic ways of doing it. You can set up a U.S. subsidiary. It's just a plain old corporation. When Paul refers to C corporations, that's just a subchapter of the Internal Revenue Code, but it's just a plain old Delaware corporation that's owned by a non-U.S. corporation. The other way to do it is to operate as a branch. And basically, when you operate as a branch, the non-U.S. company, the foreign parent itself, files U.S. tax returns. This can be done in one of two ways, which Paul touched upon. One way is that the foreign company simply qualifies to do business in whatever state it's going to do business in, and it files tax returns. The other way to operate as a branch from a tax point of view is to set up what Paul referred to as a limited liability company. And what that is for tax purposes, the big difference is the limited liability company itself is not subject to tax. So the income passes right through to the non-U.S. parent. And for tax purposes, that's the same as a branch, for operating as a branch. But at least this way you have a segregated U.S. company to isolate the liability issues, as opposed to just qualifying to do business. Each structure has its pros and cons, but I would say, as Paul mentioned, 99% of the time, a non-U.S. company will set up a subsidiary, and 99% of the time, they'll set up a Delaware subsidiary. In many cases, that's because they haven't determined what state they want to do business in, and setting up in a Delaware company gives them flexibility to qualify to do business in whatever particular state they end up doing business. So go into a little more detail. I know I have a very limited time here. If you set up a U.S. subsidiary, the U.S. subsidiary would undertake all the U.S. operations. It will likely have a contract with the non-U.S. company, then, depending upon the business you're in. The contract will, in many ways, is an attempt to fix how much taxable income is subject to U.S. tax versus how much is subject to non-U.S. tax. For example, if there's IP in the non-U.S. company, you'll license it, you'll set a royalty. If the goods are produced offshore, you'll have a contract, setting forth the transfer pricing rules to determine how much income is taxation in the U.S. and how much is taxable in non-U.S. Quite often, you'll look to what the particular rates are. Is a rate lower in the U.S., it's a rate higher in the U.S., then you'll try to obviously steer the income to where the rates are less. So people prefer a U.S. corporation subsidiary because, quite frankly, they don't want to file U.S. tax returns. Non-U.S. companies do not, in effect, want to subject themselves to filing taxes with the Internal Revenue Service, because then the Internal Revenue Service, in effect, has jurisdiction and can start looking at all of your income. In theory, the taxable income would be the same, but almost all non-U.S. companies do not want to file U.S. tax returns because they don't want the U.S. government knowing their business. Another advantage to a subsidiary is that when you sell the stock when the non-U.S. company sells the stock of the U.S. company, it's usually not subject to U.S. tax. You have to be careful of FIRPTA, which is if the company owns U.S. real estate. The disadvantages are if money is paid if you're trying to get money from the U.S. or to the actual company, and you do it through dividends, there's possibly withholding. If you do it through interest, there's possibly withholding. And I'll touch briefly in a few minutes between the different differences between dividends and interest in the U.S. I guess another disadvantage is the U.S. company, the United States may try to take the position that the non-U.S. company has a permanent establishment, that the non-U.S., if there's a U.S. subsidiary, and also, as Paul mentioned, the non-U.S. company will have reporting requirements you have to be very sensitive to. If U.S. companies are owned by non-U.S. companies, there's all kinds of reporting obligations in addition to the normal income tax returns. The taxation of a branch is that the non-U.S. company will pay tax on the U.S. source income. And if you happen to be coming in from a treaty, the treaty will allocate the U.S. income to the permanent establishment. But once again, you'll be filing, the non-U.S. company will be filing subject to the jurisdiction of the United States, and most non-U.S. companies do not want that. There's something in the United States called a branch profits tax, which is equivalent to the dividend withholding tax, but it's arguably worse because the dividend withholding tax, you can control the timing as to when you pay the dividend and when you have the potential withholdings. So that's another reason to not use a branch. At the end of the day, the reason for using a branch almost always is if you expect startup losses in the United States, you might want to have a branch to offset the non-U.S. income. But that's an unusual situation where people will do it. The disadvantage of a branch is, once again, as I said, they'll have to file U.S. tax returns, and most U.S. companies do not want to do it. As I mentioned briefly, there's United States withholding on interest and dividends. So it's very important to determine whether the country you're coming in from has a treaty with the United States, which will more often than not reduce the withholding on interest and dividends. Another thing when you're setting up a U.S. company to consider is, how do you capitalize it? You capitalize it as debt versus equity. And the reason that's so important in the United States, and it's probably similar to all countries, is United States interest is deductible, dividends aren't. So if you're looking to create deductions in the United States, you'll have some amount of debt. And another reason to get as much debt as possible is that the repayment of principal, so if you're trying to get money offshore, the repayment of principal is not taxable, whereas if you're paying dividends to the non-US company, it's probably subject to tax in the non-US jurisdiction, plus there's potential withholding. The other thing I mentioned briefly upon is transfer pricing, very important in the United States. And it's going to be equally important to the country you came in with, which, you know, everyone is worried that people are trying to shift income, which quite frankly they are, into the jurisdiction with the lower tax rate. So the United States, what's become a big business is all kinds of transfer pricing studies. And the goal is your transfer pricing is supposed to be arm's length. We always tell clients to set up agreements, to set up a file to try to find arm's length transactions with comparable transactions. The United States and potentially the non-United States company are to be very aggressive and to make sure that income isn't being shifted from one jurisdiction to the other. So that's sort of a very, very high level discussion of United States tax issues. But I said at the end of the day, most companies will use a United States corporation, set up a subsidiary, enter into intercompany contracts to try to define the income subject to US taxation. You know, usually do, you know, set up the dividends and interest versus debt and equity in a way to, you know, maximize the overall tax, considering the various rates between the United States and whatever jurisdiction it's coming into. And bear in mind, if you come into a non-tax treaty company, it may be lower tax rates in the non-US company, but there'll be much more withholding from the United States when any money is paid offshore. That's all I have for now in this. I guess I don't know if I went over or went under, but in the 10 minutes we had to discuss a topic that could take weeks and days to go over. Thank you, everyone. Bye.
Jack, thank you. A tour de force, everything you ever want to know about US tax in 10 minutes. I'm sure it'll be the same for all of you. Ted, why don't we go to IP?
Okay. Hi, I'm Ted Sabity, and I can be reached if you have IP questions at the email address I just put in the chat room. So my discussion is going to be very quick. Another topic that could take a lot of stuff, but let's talk about a short list of potential pitfalls for a foreign company coming to the United States. The first thing to recognize is that intellectual property, and by that I mean patents, copyrights, trademarks, trade secrets, and things of that nature, sometimes referred to as intangible assets, are an important part of a company's value, especially in high technology industries, even more so. So an important aspect of my first bullet point is that intellectual property is generally protected on a country-by-country basis. So, for example, let's take patents, for example. If you have a patent in Europe and you're coming to the United States and you only have a European patent, you can't, enforcing the European patent in the United States is generally not going to happen. It's the wrong jurisdiction. There's some little wrinkles about cross-border movement of processes, product by patented process and things of that nature, and that we can get into the details in another time. But the important thing is you need IP protection in the US. For example, with the patent is a good example. Another one is trademarks. Trademark is generally on a territory by country basis. And so if you have a brand in Europe, for example, and you want to bring the brand and sell the branded product in the United States, you're generally going to want to have a trademark registration with a US federal trademark registration in order to protect the brand and your investment in the brand in the United States. Copyrights is a little easier because there are a much broader international treaty over copyrights, although frankly, you still have the same problem. Trade secrets are not something you generally register, but it's important to protect the trade secret. And Therefore, you need the appropriate non-disclosure agreements that meet the U.S. requirements if you're enforcing that trade secret protection in the U.S. And this overlaps actually with what Alex is going to be talking about in employment law, because if you're hiring U.S. personnel or consultants, you need to have the appropriate agreements that are not too stringent and tough, or else they might be found to be unenforceable. And you have to understand the specific agreements protecting our trade secrets in the U.S. with regard to employees and contractors, as well as assigning their IP and their work product to your U.S. operation, presumably a U.S. subsidiary. Those have to be done right. The point is it's not automatic. You actually have to take these actions. Now, there is an important thing also to understand. You come into the United States. Not only do you have to protect your intellectual property in the United States, you have to make sure you're not stepping on somebody else's intellectual property. So, for example, you may come to the United States with your branded clothing and find out that in the United States, somebody already registered a similar brand in the US, and now this US owner of that trademark is going to sue you for trademark infringement. Similarly with patents, you may have a technology that you bring to the United States and find out that some company had this inventive idea and filed a patent on it and got a patent issued, and now they're suing you for patent infringement. And that may have to be addressed. Now, often what we do for companies coming in from foreign countries is we do trademark clearances. That's right off the bat with it, something should be considered. And then consider whether or not it's worth getting a patent clearance or not. That's something also to consider. Okay, so now the IP issues apply to both what you create and what you're integrating into your product and service, and what you import, whether physically or electronically. So even if you have a particular thing, a process in Europe, and you take the product and bring it to the United States, that could infringe somebody's patent, because there's a whole doctrine of what they call a patent infringement by a product that's where the process was patented in the United States, but somebody does the process in Europe and then imports the result. That workaround of patent law has been addressed in the courts. Again, there are other cross-border issues. If you have a foreign software service, so you have a SaaS operation in Europe, and now you take the result of that data processing and bring it to the United States, or you have the customer in the United States access the server, say in Europe or Canada, that can be an issue. I've litigated that particular issue in particular. You can look it up. So Yangaroo versus Destiny, that was a cross-border patent dispute where the servers were located in Canada. And we already talked about the foreign brand. And then you also have a question of your customer data, where you're crossing borders with customer data. Some US states have very strong privacy laws, very similar to the EU at this point, California and Massachusetts being examples. And so you need to make sure you're not falling afoul of that. So the point is that there are a number of issues that have to be addressed in the intellectual property field when you come into the United States. So if we can go to the next slide, we can talk a little bit with a little more detail. How would we do that? Now, this is very general, because this is a 10-minute discussion. This could go on. So let's talk about the trademarks. So if you have a brand in Europe, and I give Europe as an example because we have a number of European clients, extending the non-US trademark into the USA, there is actually a system for that. As I said, the trademark should be clear, but if you assume the trademark is clear, it's not already being used in the United States or registered, there's a relatively straightforward mechanism to take your European registration and turn it into a US registration. And generally speaking, there's no real time critical issue on that. Now, in contrast to that is patents. You can extend a non-US patent application into the US under the so-called Paris Treaty, but there's a time limit. You have 1 year from the priority date of the application. So if you're a startup in Europe and you've just filed a patent on your computer-related invention on January 1st, 2025, and you're going to enter the United States, you need to get that US application filed before January 1st, 2026 in order to make that priority date. And if you don't make that priority date, your foreign application may act as preemptive prior art to a later US application, even though you're filing it. So that's a very critical timing issue of taking pending applications and extending them into the United States. Now, one approach is to use the Patent Cooperation Treaty that can give you a 36-month window to make those kinds of decisions. That's something that can be discussed. Copyrights. Well, the most important thing is whether when you come to the United States, you get US assignments for the work product, the copyright work product. And the US Copyright Act is very tricky on this. And a lot of people think they understand it when they go, well, it's work for hire. Work for hire is a very tricky aspect of US copyright law. And generally speaking, this goes back to my original comment about employee or contractor IP assignments. You need to make sure that these agreements, these assignment agreements, are doing the right thing, and you're not misapplying this very popular term. Oh, it's a work for hire. And on this topic about popular conceptions about copyright law, the other one is your business model you think that works in the EU or in Asia. You come to the United States and you find out, you say, well, of course we're using that person's music, but it's fair use. Well, fair use is another tricky aspect of copyright law, generally litigated in the courts, highly fact specific. And I was at a dinner last night with some music attorneys, and I haven't checked this, but over dinner, I was told there was a recent decision yesterday that the scraping of content for training an AI was found by the court not to be fair use. I have to look this up. So I'm just telling you, I heard this last night. I had this webinar, so I haven't had time to check this, but that's what I heard at dinner last night. So what I'm getting at is these areas get fluid. So this fair use thing, you need to talk to a lawyer about it, an IP lawyer. Okay. Trade secrets, confidential information. Like I said, you have a non-disclosure agreement that works in the United States if you're doing business here. Very important. Questions of where are you going to litigate a dispute under the NDA? What's covered by the NDA? How long does the term last? Is it too strict a definition? Because under state laws, they define what a trade secret is, but that can often be a difficult threshold to meet, that your information is a trade secret under trade secret law. And there is federal trade secret law as well. And it may be that you need better agreements that are a little more permissive of what's the definition of confidential information. So there's a lot of these things that need to be straightened out and sorted out. But most importantly, you need to clear your brand before you come into the United States and invest in it. And you need to consider the patent question. And if you are a technology company with inventions that are subject to patent applications in a foreign country, you need to kind of get off the sidelines and figure out whether you should be filing in the United States. And because there's a time limit for that. And if you miss the time limit, too bad, so sad. And that's basically the entire presentation for today. That's IP in 10 minutes. If you have any questions, we have a question and answer period at the end. You have my email address. Feel free to contact me. So thank you very much.
Ted, thank you very much. I appreciate the up to the minute, decisions from yesterday are worked into your presentation.
I haven't confirmed that, Paul. I heard that over dinner. So that's why.
I learned some of my best information about the law over dinner, right? Anyway, but Ted, thank you for that. And yeah, I should have noticed, I mentioned at the beginning, please do put your questions in the chat. We could certainly take them at the end. We might take some as we go also. All right, let's move on. Alex, we're on to you.
Okay. Oh, there you go. What you need to know about employment law in 10 to 12 minutes. Again, this is going to be the tip of the iceberg, just like with everybody else. So, look, I did want to emphasize what Paul mentioned and what Jack mentioned in slightly different contexts. But yes, in employment law, you have to be cognizant of, in the United States, there's federal law and there's state law. And in employment law, it's whichever law is more beneficial to the employee. That's the employee. So typically here in New York, New Jersey, Pennsylvania, where I practice, and California as well, where I don't practice, but typically those are the main states, and there are some others where employment law is more favorable, the state law, I should say, is more favorable to the employee. So that's the law that controls. Some of the southern US states, it's either the same as federal law or not as favorable as federal law. So the federal law is the threshold, and that's what controls. So you need to know what, your state's, the state that you're doing business in, what that employment law is. And of course, that's why you need local employment counsel in the state in which you're going to be doing business in the US. So I know these slides are very packed, but let me start from the top. In the United States, for the most part, without a contract, whether it's a union contract or just a private contract, employment is at will. That means you can fire an employee or they can quit for any reason or no reason, with or without notice, as long as it's not for an illegal reason. And that's where the rub is, right? That's what's an illegal reason. Well, it would be discrimination based on race, religion, age, disability, gender, sexual orientation, national origin, ethnicity, those types of protected characteristics. It could also be retaliation for complaining about a fraudulent or illegal practice, which we call whistleblowing. Those would be illegal reasons. And more often than not, you think you're firing an employee for, a good reason, like they're not performing their job, but they may be in a protected category and they'll raise one of these issues. So, okay, we talked about, oh yes, I did want to mention too, like for example, New York City, there are some New York City laws and laws of the surrounding counties that are more beneficial to the employee than even New York State law. So you have to be cognizant of that as well if you're going to be doing business in New York City. Unions can play a role, but not for all employers if you're not unionized, which you probably wouldn't be coming, from overseas. A big issue is independent contractors versus employees. Who's an independent contractor and who's an employee? And I'm not sure what's going to happen now under the Trump administration. May not be as much of a crackdown as there has been in the past against companies using independent contractors. When you use independent contractors, you don't have to pay the employer tax. There are no withholdings for disability, unemployment that's all paid by the state. The states are losing money when you're using independent contractors. So they tend to want to crack down on companies for that reason. And there are laws about that. And it's more state specific, again, than federal law, although there is some federal law about that. It's how much you control the work. So if you have a lot of control over the work, chances are this person who's working for the company would be deemed an employee. Like I said, different jurisdictions have different rules, and certain industries such as construction may be targeted. Keep in mind too, if you don't have any employees working in the US, you don't have to worry about any of this, but it only takes one. You only need one employee working in the US. And keep in mind, let's say your office is in New York, but your employees working in New Jersey, well, they may be subject to New Jersey law. They may be subject to New York law, right? You would want to word your contracts in such a way so that the choice of law is where you want it to be, probably where your office is located, unless, elsewhere is more favorable to you as the employer. But that doesn't mean that that's the way it's going to be decided in a court. Often it's where the employee is working. Wage and hour. Overtime is a big issue. Who's exempt from overtime and who's not exempt. So there is a salary threshold. There's a federal threshold, which is much lower than some of the thresholds in some of the states. So as an example, the federal threshold right now, in order for an employee not to be paid for overtime, meaning for working more than 40 hours a week, they have to be earning under federal law at least $35,568 a year. That doesn't sound like a lot, but in New York State, it's almost double. It's $60,405 a year. And in New York City and a few of the surrounding counties, it's $64,350 a year. So California is also a lot higher. So you need to keep that in mind. Hourly employees, there are also duties tests, right? It's not just about the salary. That's, again, a threshold. In order to be exempt from overtime, the employee must have certain duties, that higher level duties than what typically hourly employees would have. And there's the executive, administrative, and professional exemptions, which I won't get into all that detail. We don't have time for that. But again, just tip of the iceberg things to be aware of. And there's some other exemptions too, like outside salespeople could be exempt from overtime. We can go to the next slide. So other issues to be aware of: paid leave. Sick leave is mandatory in most jurisdictions, but again, make sure you know what the law is where you're doing business. Vacation is usually not mandatory. Like I said, in most jurisdictions, it's not mandatory, but then there's other types of paid leave. Family leave, usually that's paid by the state. Everybody contributes to that fund. There's disability leave also by the state, although in New York State, it's through the employer needs to have disability insurance for their employees. And then there's unpaid leave where you need to keep the job open for a certain period of time, medical or disability leave, family leave, and that's what job protection is all about. Like, again, under federal law, it's 12 weeks. Every state is a little different. There's not just maternity leave, there's paternity leave, there's parental leave, all kinds of things. There's pregnancy leave, there's pregnancy accommodations that need to be provided as well, and accommodations for disabilities as well. Some key policies to be sure that you have in place. Usually, I do a lot of work with employers on their employee handbooks and putting these policies in place. Make sure you have, if you're doing business in the United States and you have employees here, an anti-harassment and non-discrimination policy, including a procedure so that employees know who to turn to if they have a complaint, and then a robust investigation process. Equal opportunity employment, which some things are changing now in the US in terms of diversity, equity, and inclusion, but you still need to provide everyone, regardless of their race, sex, nationality, ethnic origin, disability, et cetera, with equal opportunity based on merit. Reasonable accommodations, I just mentioned. For someone with a disability, as long as they can do the job and the accommodation that they need in order to be able to do the job is reasonable. It doesn't bankrupt the company. It doesn't, cost the company too much money or too much disruption. Look, you don't have to change the job responsibilities necessarily, but if there's some way you can accommodate someone who has a disability so they can do their job, then you're required to do that. Overtime, we talked about. Leaves of absence, we talked about a bit, but you need to have policies about all of this. Overtime especially, you don't want your employees running rampant with overtime, right? Because it could cost you a huge amount of money. It's time and a half. It's 1.5 times their hourly rate. And for any hours over 40 that are worked, if they're not exempt. So you want to have a policy about that they need to get prior approval unless it's something really urgent, emergent, that there is no time to get prior approval. Leaves of absence, I talked about a little bit. Again, you want to have policies about that comply with the laws in the jurisdiction in which you're doing business. Very important with social media being all over the place now, you want to have policies about what are employees allowed to post on social media, who's allowed to post, and for the company, who's allowed to speak for the company on social media. And what are they allowed to post? Again, some jurisdictions like New York, you can't prohibit employees from voicing their opinions on social media as long as it doesn't negatively impact the company. And that's where there's a fine line where you really need to talk to an employment attorney about that. And then, of course, policies regarding employee conduct, what is and isn't permissible. Look, if your country has benefits for employees that are more advantageous than what US law requires, by all means, you can continue to provide those, increased benefits. That's fine. That's not a problem. Just make sure that you're complying with US law, and not just federal law, but the law of the jurisdiction, whether it's the state or even the city where you're doing business. I'll be available to answer questions later if there are any. Thank you.
Alex, thank you for that. I'd like just make one observation quickly. Maybe you could speak to it. With my clients, everyone, like, they get their corporation set up. They deal with the tax issues. They take care of their intellectual property usually. Employment issues sometimes doesn't get as much attention early on in the life of some of these, especially these startup companies, that it needs. And I think you can probably attest to the fact that, like, you got to pay attention to those issues, because everything will be fine until it isn't. And when it isn't, it can go south really quickly. And I don't know if you have any thoughts.
Yeah. No, I do. Yeah, I totally agree, Paul. It's a kind of thing. It pays to be preventive when it comes to employment law. Like, get your policies in place early on. Get your ducks in a row so that if something happens, and it does, inevitably it will at some point, you're somewhat protected, right? You have your defenses, right? You have good defenses, or you just know what to do in those situations. Yeah, if you have nothing in place, it could bankrupt your company, quite frankly, or at least your US business. And
Yeah,
so I can't emphasize enough how important that is. Thank you for bringing that up.
Yeah, I mean, it's not a big deal to get that stuff set up, but if you don't
Right.
have it get set up, then heaven help you when it's a problem. So,
Yeah. And I did also want to say, it wasn't on the slides, but in terms of IP protections and NDAs that Ted was talking about, we do, there is some crossover with employment law and IP law, and we do partner with people like Ted to to get those things, make sure that that it's that the company's protected.
yeah, absolutely. All right, great. Alex, that was great. Thank you so much. Michael, that brings us to you.
Thanks, Paul. I'll have my audio on and my video on this time, so appreciate it. Again, my name is Michael Cerati. I'm the senior partner of Cerati Law. We do immigration. We've been doing it for many years, and we represent hundreds of startups as well as large corporations, individuals, and investors. There was a question early on in the seminar that talked about, who do I speak to first? Perhaps I'm a little biased, but I would say you speak to an immigration lawyer, because if it's critical for you or your people from your foreign company to be here in the United States, you have to understand, how do you get here other than getting on a plane, right? And what are those activities? And then often a visa option might require a type of investment in a type of corporate structure that you'd rather do in the beginning than later on and try to fix it to align yourself with the immigration solution. Then, of course, once you're here, you have all those employment law issues and tax issues and where you're going to do business. That all plays into the immigration play. That being said, there's really no cookie cutter solution for immigration. In almost every instance, it's a matter of the individuals and the companies, who's coming, what their citizenship is, where they operating, how long have they been operating, are they coming here for a short-term basis, what is their actual activities in the United States, are they looking for a green card, right? Do they want their spouse to come? Does their spouse need to work? What about family members? Do they want to go to school? So all those issues play into a solution. And I'll give you an example before I get into the slide. in the breakout, I was asked a question from an individual who came from a certain came from a country that actually does have a treaty in the United States that allows for a certain type of visa called an e-visa, but they're operating in a different country. Well, how long have they been operating? Well, over 3 years. How many people are working in that company? 5 to 6. Great. That opens up a number of avenues in terms of visa solutions, including the L visa, which is an intercompany transfer, and an E visa, which is the investment visa. Another question is, how quickly do you want to get here? Do you want to get here in the next 2 to 3 months? And do you want to be working and setting up an office? Or maybe you're planning on the 3rd or 4th quarter of 2025? And then who's coming? And are you planning on actually operating the company outside the United States when you come here? So all those questions obviously require answers. And the way we typically would operate is that we sit down and we ask these questions, we get the information, and then we say, okay, here are the number of options that you have. These visas, okay. Here's the estimated cost, the timeline, the tenure, how long you can be in the United States, does it lead to a green card? So all that information can be gathered fairly quickly, provided you with an outline of what you can and cannot do. And often I will say, hey, look, you got to go speak to the corporate lawyer. You got to speak to the tax person because you have some tax considerations. If you're going to be hiring people and you're going to be in California and New York, you better speak to an employment lawyer because there's some considerations there, especially if you want to hire a bunch of contractors. So again, all that plays in what's the best visa for me to have to come to the United States to grow the business. And speaking of which, it is a journey, right? What's my first step? Am I coming here to look at where I want to open up an office, all right? Or am I already selling, all right, to the United States and I want to sell more of my products that made outside the United States? Or perhaps I'm coming here and I have a fairly decent sized company, 40, 50 people in India. And now I want to go out and raise money in the US capital markets through a VC. So there's a lot of activities that you can come here strictly as a B1 business visitor. And if you're coming from most European countries, you probably know there's something called ESTA, which you go online, you pay $18 and you get basically a 90-day visa. You don't have to go to the consulate to get a visa to come to the States. And when you're here, you can do a lot of these B1 business visitor activities, right? The only thing I caution clients on in terms of coming as a business visitor is, one, promoting yourself as a president or an executive of the US company when you don't have work permission. Because when you do that and you step foot in the United States and you perform certain activities, you're technically working. Now, will that get you in trouble there when you're in the United States? Nah, probably not. But it is possible the next time you enter the United States, the officer types you in the web, sees that you're the CEO of a US company based in New York City, and they're like, you don't have a work visa. What are you doing here? Normally, they'll give you a warning and tell you to go get yourself straightened out with the visa. But sometimes if the officer's having a bad day, they may not let you in the United States. But one of the most important activities that any entrepreneur can do is probably raise capital. And you should understand that raising capital in the United States, going to investors, angels, VCs, and so forth, that's a permissible business activity. You can do that as a visitor. Now, once you've decided, okay, I need to be here, I need to grow the company, or I want to send my key people to the United States, that goes back to, all right, what's the best visa to have? Briefly, the E visa, E1, E2. The US has treaties with about 30 different countries, most of the EU countries, some of the Asian countries, and that treaty allows you to get what they call an investor visa, which is an E2, or an E1, which is a treaty. And the key components are very simple. One, that the US entity has to be controlled by the citizens of the treaty country. So that means 50% or more. Does not have to be owner. Control means you can have 45% and 40%, and have a voting proxy over the other amount that gives you up to the 50%. And this is important if you're going to have a US co-founder, and the only solution at the moment is going to be the e-visa, right? And the investment visa is, hey, it's controlled by, let's say, a German citizen. I'm making an investment into the United States, right? And then I'm going to create jobs in the United States. And that investment is important. It doesn't necessarily have to be cash. It can be IP if we can value the IP, right? Also, if you own more than 50% of the US company, your investment has to be at risk, and it really should be the first money into the company. So if you go out and raise a couple $1 million from a VC, and then you put in $50,000 to $100,000 after you spent money from the VC, that might be difficult to get that visa because you can't really prove that that first money in, which should have been your money, was necessary. We'll go to the next slide for a second, please. So that's the e-visa, all right? There's also the L visa, and this goes back to the conversation I had with the participant. He's got a company, it's been operating for 3 years. He's got a bunch of people working for the foreign company. You know, the L visa is an intercompany transfer visa, and it's a great visa for 2 reasons. One, you can be a citizen of any country. So for example, India, we do not have a treaty. So a lot of our Indian entrepreneurs and companies do get L visas. 2, it can be done fairly quickly, meaning that if you have all the paperwork in place, and you can probably be here in about 3 months. 3, it allows you to ultimately get a green card if you're able to build the company in the United States and continue to operate the foreign company. Number 4, it's called dual intent, meaning that when you come to the border and you indicate to the officer that you want to live here permanently, that's an immigrant intent. Officers could deny your entry if you don't have the proper visa. The L1 allows you to have that dual intent. So when you come here, you build your company, you want to get a green card, that L1 not only allows you to file for the green card, but you can travel in and out of the United States while you're processing for the green card. There's no minimum investment. The investment is basically, look, this is the amount of capital I need to get the business going. And the only downside to the e-visa is that if you're opening up a new office, it's a 1-year visa. Now, also, there's something called the O visa and the H visa. If you're outstanding in your field, right, and you can demonstrate that by meeting a number of criteria, you could get the O visa. And the O visa is an excellent visa if you're in the position to get it, because it allows you to operate in the United States as a CEO, as a manager, as an entrepreneur. You can get it at any time during the year. You're not limited by any sort of lottery like the H-1B, and it can be extended almost indefinitely, right? It also is a stepping stone to a green card through the EB-1 extraordinary ability. The H-1B is a very commonly known visa. It's for people who basically have a degree and are going to work in a degreed profession. The downside is that they have a lottery every March. And if you win the lottery, which is usually around 40% chance mostly, you can process it and you get here by October, but it's a lottery, right? So, I always encourage our clients to at least register for the lottery. And if you win the lottery, that's great. And you get the approval notice, that's great. You can keep it in your back pocket, because ultimately, if you end up selling your company or perhaps moving to a different company, you can't with the E and the L, but you can with the H and the L. And then there's a few other options for citizens of certain countries. If you come from Canada or Mexico, there's a TN. Chile, Singapore, and Australia, it's basically the H-1B, except there's no lottery limitations, and it's really easy to get in terms of processing at the consulate. Last but not least, nothing else works except maybe you can get a cap-exempt H-1B. What does that mean? Well, the laws have changed a little bit, and they've opened it up. Basically, the cap-exempt means you don't have to participate in the lottery. So you can get this almost at any time. The key is you have to show an association with like a nonprofit research organization or a university. So in the startup space, there's often professors or founders who are associated with universities that we can strategize and get these types of visas. Anything else?
All right, Michael, thank you.
Was that within the 10 minutes, Paul? Yeah.
Pretty close, pretty close. Thank you, Michael. One thing that I hope participants are starting to recognize is the interrelationship among these different topics that we've addressed. So, when, for example, when I have a client that comes to me, I'm bringing my company to the U.S., there are a few things right off the bat. I need to talk with Jack about make sure we get the right structure, for tax considerations. First thing I'll say is, like, are you or any of your colleagues overseas planning to come to the U.S. to operate the business? If so, then we get Michael involved. And as Michael notes, we do that at the outset, while we're making the decision about how to structure the entity, because there are important considerations in how you set up the company that will have implications for immigration considerations as you move forward. So, and as other examples, Alex and Ted mentioned the interplay between employment and intellectual property. So there are a number of, and Alex and Michael, employment and immigration. I mean, there are many ways in which these different considerations and different disciplines come together. And I think when we have clients that come in and talk to us, I'm bringing my company to the U.S., that's part of our role, is to think about, okay, what are the issues? Like, for me, a question right off the bat will be, do you have a trademark? Do you have U.S. trademark rights? Or what about patent? Then you need to talk to Ted. So again, these are all the interrelated factors, and they all need to be taken proper note of in terms of coming to the U.S. But I will say again that relatively speaking, setting up a company in the U.S., addressing all of these issues, is relatively straightforward relative to the benefits. And so, when we have clients that are coming to the U.S., we need to make sure these things all get taken care of. But the benefits are always seem to be significant. Let's go to the next slide quickly. I just want to make a couple of quick observations on service providers. Beyond the lawyers who you've heard from, there will be other people that you need to speak to when you're bringing your company to the U.S. In particular, accountants and bankers. When I speak with a company coming to the U.S., that is usually one of my first questions. Do you have a U.S.-based accountant? Because if they don't, they will almost certainly need one. And we can always make recommendations to accountants, bankers as well, different types of consultants, insurance brokers. There are a number of different types of disciplines that can become important when you are coming to the U.S. What to think about when selecting? You want to work with, especially, let's talk about accountants. That's a good example, comes up all the time. People who they have experience working with overseas companies and cross-border issues. Many of the clients I work with are small to mid-sized companies. So I caution them, make sure you're getting an accountant that is, has enough heft and experience to be able to deal with your issues, but not too large. You don't necessarily need a PwC, for your small to mid-sized company. They won't give you good attention, and it'll cost you too much. So, think about, for example, all the people on this call, we all have smaller firms with expertise in the space. That's a good choice for a small to mid-sized company. You'll get the cost right, you'll get the right level of attention, you get the right level of expertise. In terms of recommendations, and as I say, I brought this up in the context of the accountants. I work with a number of accounting firms and bankers that have experience working with offshore companies entering the U.S. They can get the sort of that relationship of cost, expertise, attention correct. In terms of recommendations and other service providers, your U.S. lawyers. The five of us can often make recommendations. Think about your Chamber of Commerce in your home country, foreign trade offices. I've worked with a lot of foreign trade delegations over the years. They often are a good source of recommendations to the various service providers you'll need. With that, I want to go quickly to some Q&A. Alex, a question for you. Are there any labor/tax, maybe for Jack, are there any labor/tax risks in the U.S. if the U.S. subsidiary operates solely through contractors worldwide without a physical presence in the country?
From an employment perspective or independent contractor perspective, probably not, because it's typically, if the contractors are not physically in the US, they're not going to be subject to US law or US jurisdiction. So, I hesitate to say never, that could never be an issue. And again, but if they do frequently visit the US, if there is a US office, and they frequently visit the US office, or they frequently come to the US to do work for the company, then it could become an issue, particularly when it comes to workers' compensation. And in New York in particular, in New York, there's a threshold, I believe it's 600 hours. If you work more than 600 hours in New York State, you need to have workers' compensation insurance in New York. So, that's just one small issue, but yeah, if they're never in the US or hardly ever, it's probably not an issue from an employment law perspective.
Great, thank you. I also have some questions that came up in the registration process I'm going to try to hit. Ted, can you talk quickly about chain of title and the importance of chain of title for IP assets when you're selling your company or getting an investment, and the extent to which that becomes an issue for your foreign?
On the early stage of the company, the investors typically, especially for both high tech and in the fashion realm, they want to see in the high tech realm, you have some IP, typically in the form of patents, often in terms of the copyright to the software. And I am increasingly involved in the question of data ownership and its interaction with artificial intelligence. In fact, I'm giving a paper in May on this at the International Tech Law Association in San Diego, because that is turning into a bigger issue. So how do you establish ownership? That's the chain of title. You have to make sure that the right paperwork is in place. The paperwork meets the requirements to establish transfer of ownership from inventors and creators to the company, because that's going to be the vessel in which the value is put together. And the same applies with branding in a fashion business. And you have to have the appropriate papers filed at the various assignment offices to make it a matter of public record that these assignments have been made, and that establishes that the company owns the stuff, and that's what the investors like to see. Equally, and they will, in due diligence before the investment, they're going to check. Their lawyers are going to check for all this. Similarly, as Paul mentioned, on the exit, when selling the company, the people who are going to buy the company or looking at the company to buy it, they're going to go through the same process. They're going to look to see if these papers are in place, and they're going to ask, what are these things? And they're going to look and make sure that that we've actually attended to those things. So that's an important topic.
Thank you, Ted. Alex, benefits. Many of the people that are listening in are from Europe, where the context of benefits for employees is completely different. So much of it is state benefits. What can you give advice in terms of what you see the importance of? I mean, I know this is not sort of a legal issue, but it's one that you probably see a lot. The importance of foreign companies thinking about what they need to offer in terms of benefits in the US in order to be competitive in the workplace here?
Yeah, so I mean, even though in most states vacation is not mandatory, most companies do provide paid vacation. So, again, it depends on the level of the employee. An executive, it could be as much as a month paid vacation. A lower level employee could be 1 to 2 weeks. Paid sick time is, in New York and New Jersey, it's 40 hours a year. And there are some variations on that in New York. But again, if you're used to, as a company, providing greater benefits than that, by all means do that. One thing to be careful about is if you have expatriates working in the United States and you're providing them with the benefits that, are mandated by your country, but you don't provide your American employees with the same level of benefits, that could be a problem. You want to make it across the board.
Alex, thank you for that. Another question. Michael spoke to this a bit. Which type of lawyer is best to start with when it comes to an initial consultation about market entry? Corporate? Tax? I don't know.
Oh, me, of course.
Who'd like to pick that up? Corporate, of course.
Immigration. You got to figure out if you can get here.
I don't know. I think
I would say,
Go ahead,
I would say that to some extent, it doesn't necessarily matter as long as you haven't established a foothold in the United States and, open up bank accounts, put money in, incorporate. Because from an immigration standpoint, if you have done that, it may preclude you from one of the immigration solutions. So I have seen situations where companies have been set up, money's been transferred, Americans have been hired, but because of the way they did it and the way it was structured, it became more difficult to bring people from across the pond to the United States, right? So would be an added cost to restructure the way the company is structured to have that immigration solution, But I would say from my experience, because I probably handle, I don't know, 2,500 cases a year. As long as your first thought is, all right, we need to expand to the United States, you come to one of us. The other ones recognize, okay, you better speak to the immigration lawyer. You better speak to the corporate lawyer. You better speak to the IP lawyer, right? And then when you have all that information, it doesn't necessarily cost a lot of money, guys, because most of us will give a quick call for no cost, I think. But, at least then you have this basic information and then you can make an informed decision. But I would, again, vote for the immigration lawyer because I'm biased.
Yeah, look, I think it's fair to say, as Michael notes, when someone comes to me saying I'm bringing my company to the U.S., the first thing I'm thinking, I get a lot of information from them right off the bat. As I said, do you have a trademark? Are you going to have employees? What is your what's the appropriate tax structure? Are you guys going to have people coming to the country early on? And based on that, I'm going to think about, okay, who do I need to bring in Jack? Do I need to bring in Michael? Do I need to send them to Ted? Whatever it is. So I think Michael's right. Wherever you start, the important thing is to make sure that that the proper issues are getting addressed early on, and so you don't foreclose opportunities by going too far down the line before you've gotten the right advice. So, all right. I think I've gotten through most of.
There was one question that dealt with Dooley and Rippling. Dula and Rippling. Do you advise clients away from tools like Dual and Rippling, which are, my answer from an immigration standpoint is Not necessarily. I think they provide a real value in the marketplace, especially if you have employees at multiple different countries. The problem can occur where you don't necessarily have a paper trail to demonstrate supervision and control over those employees within your organization. And supervision and control is important when it comes to certain types of visas, right? And to understand that and to make sure you have certain documents in place so you can demonstrate to U.S. immigration, hey, look, even though we pay them through Rippling, right, they literally do work for us. Look, here's their email address. Here's their Slack channel. Here's their, IP non-disclosure agreement, and so on and so forth. So it can be a bit of a hill to climb, but not necessarily, as long as you clearly oversee their activities and you effectively can fire them and hire them at any time.
I want to say from an employment perspective, there are other issues regarding joint employment, right? So in certain circumstances, even if somebody else pays your employees, like you hire them through an agency, they're paid by the agency. But if you have, as Michael said, supervision and control over them, then you could be jointly liable for, alleged discrimination, for example. And on the other hand, as an employer and as a company, don't you want to have control over your employees? Don't you want to know what they're doing? Don't you want, ceding that control to somebody else and then not necessarily knowing, are they following the laws that you need to be following? You want to make sure that they're doing the right thing. Or
Well,
you just take control.
I will also note, I'm just going to touch on this quickly. There are also issues that come up in connection with equity plans. For personnel that are not your employees, the extent to which you're allowed to issue them equity, which is often important for these startup companies. But I think we are out of time at this point. We are going to breakout rooms again, so feel free to please. You can join. Hopefully, most of us are able to go to the breakout rooms. We can speak further. You have our contact information, and feel free to reach out to any of us. With that, Doug, I'm going to turn it back to you. And I'm going to thank the panel for your participation. This was great.
Thanks, Paul, guys.
Thank you, Paul, for having us.
Yeah, thanks, Paul. And thanks, Alex, Jack, Michael, and Ted. Great stuff. And just want to remind everybody that we'll be posting the recording on our YouTube channel. We usually do that within a day or two, so you can find it there and look at it at your own pace. With that, I'll hopefully see you at the next event, and thanks for attending.
Thanks.
Thank you.
Have a good day.